You can't just walk in here demanding things like you own the place.
I'm asking to see my children.
Your daughter has marks on her body and you expect us to just ignore it? Families like yours always have an excuse.
What exactly do you mean by that?
I mean, we've seen this before. Defensive, confrontational, acting...
At 11:47 a.m., inside the front office of Maplewood Elementary School, a white principal stood with her back to the hallway, phone pressed to her ear, and said calmly, "Yes, I need an emergency removal. The children are in danger." Two CPS workers were already walking through the front doors, lanyards swinging, clipboards in hand. The black woman standing 6 feet away, watching this unfold, was not who any of them thought she was. Her name was Nadine Coulter. She was a sitting federal judge on the United States District Court, Eastern District, appointed by the President, confirmed by the Senate, and responsible for presiding over the very type of civil rights case that was now playing out in real time against her own family. Her children, Elijah, 10, and Amara, 7, were sitting in a locked classroom down the hall. Amara had been crying for 20 minutes. Elijah had asked 3 times to call his mother. Both requests were denied. Principal Janet Driscoll had made her decision the moment she saw a bruise on a little black girl's knee. She never consulted the school nurse. She never called the mother. She called CPS and requested emergency removal, using words like imminent danger and signs of physical abuse on multiple children. The school's security cameras were recording everything, every hallway angle, every office entrance, every frame of what was about to become one of the most explosive civil rights cases in the state's history. Driscoll had no idea what she had just set in motion. Before we continue, comment where in the world you're watching from, and make sure to subscribe because what happens next will leave you speechless. Janet Driscoll had been an educator for 18 years, the last 9 as principal of Maplewood Elementary in the affluent, predominantly white suburb of Lake Ridge. On paper, she was a model administrator, involved, organized, and fiercely protective of what she called the culture of this school. In practice, that protectiveness had a pattern. Over the past 6 years, Driscoll had filed 14 CPS referrals against families at her school. 13 of those families were Black or Hispanic. Not a single referral resulted in a substantiated finding of abuse or neglect. Every case was closed. Every family was cleared. And every time, Driscoll moved on to the next one without consequence. Parents had tried to push back. 3 families filed formal complaints with the school board, describing a principal who scrutinized their children more closely, questioned their home lives more aggressively, and treated normal childhood incidents as evidence of dysfunction. The complaints were reviewed internally and quietly dismissed. Driscoll had connections that insulated her. Her husband, Gary Driscoll, sat on the Lake Ridge City Council. Her sister-in-law, Rita Driscoll, worked as a caseworker in the county CPS office. Between the school board, city hall, and child services, Driscoll operated inside a network that had never once held her accountable. She believed she was the gatekeeper of her community, that her judgment about which families belonged and which didn't was not just valid, but necessary. In an email sent to a colleague 2 years earlier, she had written, "Some families just don't belong in a school like this. It's not about race, it's about standards." That email would later be entered into evidence. But on this Wednesday morning, none of that history mattered to Driscoll. She had found what she believed was her next case. A bruise on a black child's knee, and she was already making the call. Nadine Coulter's path to the federal bench began in the Raymond Rouse housing projects in West Baltimore, where she shared a 2-bedroom apartment with her mother and 3 siblings. Her mother worked double shifts as a hospital custodian and kept a rule in the house that was never negotiable: homework before anything. Nadine earned a full academic scholarship to Howard University, graduated summa cum laude, and was accepted to Yale Law School, where she finished top of her class. She clerked for a Supreme Court justice, spent 6 years as a federal prosecutor specializing in civil rights cases, and at 39 was appointed to the United States District Court for the Eastern District, making her one of the youngest black female federal judges in American history. Now 43, she presided over civil rights and constitutional law cases. She had ruled on police misconduct, housing discrimination, and unlawful government overreach. Her opinions were cited in law reviews. Her reputation on the bench was precise, fair, and unmovable. Her husband, Derek Coulter, was a trauma surgeon at the city's largest hospital. 2 years ago, they moved to the Lake Ridge district specifically for the school ratings. Elijah, their son, was gifted and quiet, reading 2 grade levels ahead. Amara, their daughter, was social and artistic, the kind of child who made friends on the first day and drew pictures for her teachers. Both were model students, no behavioral issues, no academic concerns. Nadine volunteered at school events, attended every parent-teacher conference, and donated to the annual fundraiser. Despite all of this, from the very first week, she felt the resistance. Driscoll's greetings were colder to her than to other parents. Her children's behavior was scrutinized more closely. Minor incidents that were laughed off for white students were flagged and documented for hers. At one conference, Driscoll asked Nadine about her home environment 3 separate times. Nadine noticed. She always noticed. She just never imagined how far it would go. That Wednesday morning started like any other. Nadine pulled into the Maplewood Elementary drop-off lane at 7:45 a.m., kissed both children goodbye, and watched them walk through the front doors. Amara wore a navy skirt and a yellow top, her backpack bouncing with each step. On her left knee was a small bruise, greenish-purple around the edges, from falling off her bicycle in the driveway 2 days earlier. Derek had cleaned it, put a bandage on it, and by Monday morning, Amara had forgotten about it entirely. A teacher noticed the bruise during morning circle and, following school protocol, reported it to the principal's office. Protocol required documentation and, if warranted, a call to the parent. Driscoll skipped the call. Instead, she pulled Amara out of class and brought her to the principal's office alone. No parent notification, no school counselor present, no nurse consulted. For nearly 20 minutes, Driscoll questioned a 7-year-old girl behind a closed door. The questions were leading, repetitive, and designed to produce a specific answer. Does mommy or daddy ever hurt you? Do they hit you when you're bad? Are you scared at home? Has anyone told you not to tell? Amara said no each time. She said it clearly. She said it repeatedly. And each time, Driscoll pressed harder. The hallway security camera captured Amara being led into the office with a confused expression and Driscoll closing the door behind them. 20 minutes later, it captured Amara leaving in tears. Driscoll then had Elijah pulled from his 4th grade classroom. Same office, same closed door, same questions. Elijah, more composed than his sister but visibly uncomfortable, answered no to every question and then asked, "Can you call my mom?" Driscoll looked at him and said, "That's not necessary right now." She had already decided what she was going to do, and calling the mother was never part of her plan. At 10:15 a.m., with both children back in their classrooms, still shaken from the interrogation, Driscoll sat in her office and picked up the phone. She did not call Nadine Coulter. She did not walk down the hall to consult the school nurse, Karen Whitley, who would later confirm under oath that the bruise on Amara's knee was entirely consistent with a minor fall, and that no one from the principal's office ever asked her to examine it. She did not consult the school counselor. She did not review Amara's or Elijah's files, which contained no behavioral flags, no prior concerns, and no history of anything other than 2 well-adjusted children excelling in their classes. Instead, Driscoll called the county CPS hotline and reported suspected child abuse. The language she used was deliberate. She described imminent danger and signs of physical abuse on multiple children. She called the parents uncooperative and possibly violent, a characterization based entirely on a brief exchange 2 weeks earlier, when Nadine had questioned why Amara had been moved to a different reading group without notice. That single conversation, a mother asking a reasonable question, became Driscoll's justification for the word aggressive in a government report. Then Driscoll made a second call. This one was to her sister-in-law, Rita Driscoll, a caseworker in the county CPS office. Text messages recovered during the investigation would later show the exchange. Janet wrote, "I need you on this one personally. The mother is difficult, very aggressive. You know the type." Rita responded within minutes. "I'll take care of it. These ones always think they're above the rules. Rita agreed to handle the case directly. No conflict of interest was disclosed. No supervisor was informed. The referral was flagged for emergency response, and 2 caseworkers were dispatched to the school before lunch. Nadine was on the bench when her personal phone vibrated in her chambers at 11:22 a.m. She ignored it. It vibrated again, then a third time. During the next recess, she checked and found a voicemail from Ms. Alicia Grant, Elijah's teacher. The message was brief, her voice low and careful. "Mrs. Coulter, I think you need to come to the school. Something is happening with your children. I can't say more right now, but please come." Nadine didn't call back. She informed her clerk, stood up from the bench mid-session, and drove to Maplewood Elementary still wearing her professional attire. She arrived at 11:40 a.m. The front office felt wrong immediately. The receptionist, who normally greeted her warmly, avoided eye contact. Another staff member turned and walked into the back hallway when she entered. Nadine said, "I'm here to pick up Elijah and Amara Coulter." The receptionist stared at her screen. "If you could just have a seat, someone will be with you shortly." Nadine did not sit. A moment later, Driscoll emerged from the hallway. Her expression was composed, rehearsed. "Mrs. Coulter, your children are being evaluated right now. You can't see them at this time." Nadine's voice was steady. "I'm their mother. Bring me my children." Driscoll folded her hands. "Ma'am, I've contacted the appropriate authorities. It's out of my hands now." "What authorities?" Driscoll paused, just slightly. "Child Protective Services. We have concerns about marks on your daughter. We have a duty to report." Nadine's expression hardened. "She fell off her bicycle on Saturday. I have photos. My husband cleaned the scrape himself. He's a surgeon." Driscoll shook her head slowly, her voice dropping into something almost patronizing. "That's what they all say." The words hung in the air, and at that exact moment, through the glass doors behind Nadine, 2 CPS workers walked into the building. The 2 CPS workers came through the front doors with the practiced efficiency of people who had done this many times before. Rita Driscoll walked in front, lanyard swinging, clipboard already open. Behind her was Tom Wilder, a junior caseworker in his late 20s who had been on the job for less than a year. Rita did not introduce herself by her full name. She did not disclose that the principal who made the referral was her sister-in-law. She looked at Nadine the way she might look at a case file, not a person. "We're here to conduct an emergency assessment regarding your children, Elijah and Amara Coulter. Based on the referral we've received, there are concerns about physical abuse. The children may need to be placed in temporary protective custody pending evaluation." Nadine's hands trembled at her sides, but her voice did not break. "You are not taking my children. I want to see the report. I want to know the specific allegations." Rita shook her head. "I'm not able to share the details of an ongoing investigation at this time." She opened her clipboard. "I'll need to ask you some questions. Do you or your husband use physical discipline in the home? Are there firearms in the residence? Has either parent struggled with substance use?" Nadine answered each question calmly, directly, and without hesitation. Then she said, "I know my rights. You cannot remove my children without a court order, unless there is immediate, verifiable danger. There is no danger. My daughter has a bruise from a bicycle fall. No one in this building even consulted the school nurse." Rita's expression didn't change. "We'll make that determination, ma'am." Behind her, Tom Wilder shifted his weight. He glanced at Nadine, then at the hallway where the children's classrooms were. He leaned toward Rita and whispered, "This doesn't seem right. There's nothing here." Rita didn't turn her head. She simply looked at him with an expression that ended the conversation before it started. Wilder stepped back and said nothing more. Rita looked at Nadine and delivered the words as though reading from a script. "We'll be taking the children for a 72-hour evaluation at a designated facility. You'll be contacted with the details." Nadine's voice was immediate. "Absolutely not. You have no court order. You have no evidence. You are not removing my children from this school." Driscoll, who had been watching from the hallway, reached for the phone on the front desk and dialed the school resource officer. Dale, I need you in the front office. We have a situation. Officer Dale Mounier arrived within 2 minutes. He was 44, white, broad-shouldered, and carried himself with the kind of authority that expected compliance, not conversation. He had 3 excessive force complaints in his file over the past 5 years, all dismissed internally. He stepped into the office and positioned himself directly behind Nadine. Rita gestured toward the hallway. "We need the children escorted to our vehicle." Nadine turned and stood between Mounier and the corridor. Her back was straight, her feet planted. "You will not touch my children." Mounier exhaled slowly. "Ma'am, don't make this harder than it has to be." Through the glass walls of the front office, parents arriving for early pickup began to slow down. A woman stopped mid-step on the sidewalk, staring. A man in a parked car lowered his window. Phones came out. A black father named James Whitfield pushed through the front doors and stepped inside. "What's going on here? Why are you doing this to her?" Mounier pointed toward the exit. "Sir, this doesn't involve you. Step outside." Whitfield didn't move. "I'm not leaving. I'm watching." In the hallway behind Driscoll, teachers had gathered near their classroom doors. One of them, Miss Alicia Grant, the same teacher who had called Nadine, walked toward the office. Her voice was quiet but steady. "Those children are fine. I see them every single day. This is wrong." Driscoll turned sharply. "Miss Grant, return to your classroom, now." Grant held her gaze for a moment, then stepped back. But she did not stop watching. No one did. The security cameras above them recorded every frame. Mounier reached for Nadine's arm. His fingers were inches from her sleeve when she stepped back, not in panic, but with the controlled precision of someone who understood exactly what was happening and exactly what came next. She reached into her jacket, pulled out a leather credential case, and held it up at eye level. "My name is Judge Nadine Coulter. I sit on the United States District Court, Eastern District. I preside over civil rights and constitutional law cases, including cases exactly like what is happening in this room right now." The room went silent. Not quiet, silent. Rita's face drained of color, her clipboard lowered to her side. Driscoll, who had been standing near the hallway with her arms crossed, froze. Her mouth opened slightly, but nothing came out. Mounier's hand dropped to his side as though the air itself had pushed it down. Nadine held the credential steady, her voice cutting through the stillness with surgical control. "You have fabricated an emergency to remove 2 healthy, well-loved children from their mother based on a bicycle bruise. You have interrogated my 7-year-old daughter behind a closed door for 20 minutes without my knowledge or consent. You have pulled my son from his classroom and questioned him without a parent, guardian, or counselor present. You have used language in a government referral that you know to be false. And you have attempted to use a family connection inside this CPS office to fast-track an unlawful removal." She turned and looked directly at Rita. "I know who you are. I know your maiden name is Driscoll. I know the principal of this school is your sister-in-law. And I will be requesting a full conflict of interest investigation before the day is over." Tom Wilder took a visible step away from Rita. His clipboard hung at his side. He stared at the floor. Driscoll sat down slowly in the nearest chair, her face slack. James Whitfield, still standing near the door, exhaled audibly. Through the glass, 2 parents had their phones raised, recording. No one in the room moved. No one spoke. Because every person standing in that office understood that the ground beneath them had just shifted in a way none of them could undo. Nadine did not wait for anyone in that room to find their voice. She stepped into the hallway, pulled out her phone, and made 2 calls. The first was to her husband, Derek. She spoke in short, precise sentences. "I'm at the school. They tried to take the children. CPS was called on a fabricated report. I need you here." The second call was to her judicial chambers. Her law clerk, Daniel Reeves, answered on the first ring. Nadine's instructions were specific. "Contact the county CPS director immediately. Then call the State Inspector General's office. Then the U.S. Attorney's Office Civil Rights Division. I want all 3 notified within the hour." Reeves didn't ask questions. He started dialing before she hung up. Within 30 minutes, the calls had landed. The county CPS director reached Rita Driscoll on her cell phone. The conversation was brief. "You are to stand down immediately. Do not touch those children. Do not speak to the mother. A supervisor is on the way. Do not leave that building." Rita said nothing. She sat down in the front office and placed her clipboard on the desk, face down. At the same time, the school district superintendent received 4 separate calls from parents who had witnessed the scene through the glass office walls. One parent had already posted a video to social media. A local news producer received a tip from someone in the parking lot and dispatched a crew. By 2 p.m., Nadine was in the locked classroom with her children. Amara ran to her, tears streaming, and pressed her face against her mother's chest. "The lady kept asking if you hurt me, Mommy. I told her no. She kept asking." Elijah stood by the wall, arms folded, jaw tight for a 10-year-old. "I told them you didn't do anything. They didn't listen. They didn't care." Nadine held them both. She kept her voice even. She told them everything was going to be okay. She walked them through the hallway, past the silent office staff, past Driscoll's closed door, and out into the parking lot. She buckled them into the car, closed the door, sat in the driver's seat, and for the first time that day, broke down completely. The investigation moved faster than anyone at Maplewood Elementary expected. Within 48 hours, federal and state investigators had secured the school's security footage, every frame preserved and cataloged. The cameras told the story Driscoll had hoped no one would see. Amara being led down the hallway into the principal's office, her small face confused, the door closing behind her. 20 minutes later, the same door opening and Amara emerging in tears. Then Elijah, pulled from class, escorted into the same office, the same closed door. The footage showed Driscoll making 2 phone calls afterward, one to CPS and one to a personal number that records confirmed belonged to Rita Driscoll. Investigators subpoenaed the text messages between them. The exchange was devastating. Janet had written, "I need you to handle this one personally. The mother is difficult, very aggressive. You know the type." Rita's reply came 4 minutes later. "I'll take care of it. These ones always think they're above the rules." Those messages would later be read aloud in a courtroom. Driscoll's email history revealed the broader pattern. Over 6 years, she had filed 14 CPS referrals. 13 involved Black or Hispanic families. Not one was substantiated. Every case was closed without findings. The school nurse, Karen Whitley, filed a sworn statement confirming that the bruise on Amara's knee was entirely consistent with a minor fall, and that Driscoll never consulted her before making the report. Ms. Alicia Grant and 3 other teachers provided statements confirming the Coulter children were happy, well-adjusted, and showed no signs of abuse or neglect. 2 of those teachers went further. They revealed that Driscoll had pressured them on multiple occasions to document minor behavioral incidents involving minority students, things like talking out of turn or forgetting homework, while identical behavior from white students was ignored entirely. The pattern was not subtle. It was systematic, and now it was on the record. The U.S. Attorney's Office did not wait for the internal reviews to run their course. Within 2 weeks of the incident, a federal civil rights investigation was formally opened. The charges came down 1 month later. Janet Driscoll was charged with conspiracy to deprive civil rights under 18 U.S.C. Section 241, filing a false report to a government agency, and abuse of authority in connection with her role in public education. The indictment detailed not only the Coulter case, but referenced the pattern of racially targeted referrals spanning 6 years. Rita Driscoll was charged with abuse of authority, conflict of interest, and conspiracy. She was terminated from the county CPS office the same day the charges were announced. Her supervisor issued a statement confirming that Rita had never disclosed her familial relationship with the referring principal, a direct violation of agency ethics policy. Officer Dale Mounier was placed on unpaid leave pending a full investigation into his role at the school and the reopening of 3 prior excessive force complaints that had been previously dismissed. The Lake Ridge School Board convened an emergency session. Driscoll was terminated by unanimous vote. Board members who had previously dismissed complaints against her sat in silence, as the security footage played on a screen in the closed session. Two of them would later face public calls for their own resignations. Gary Driscoll, Janet's husband and sitting city council member, resigned within the week. Investigators had uncovered evidence that he had used his position to intervene with the school board on 2 prior occasions when complaints about his wife were escalating. His resignation letter cited personal reasons. No one believed it. Tom Wilder, the junior CPS caseworker who had whispered, "This doesn't seem right," in the school office that day, cooperated fully with federal investigators. He was not charged. His testimony detailed how Rita had directed him to bypass standard intake protocols, skip the supervisory review, and move directly to emergency removal without sufficient evidence. He said he had objected quietly, and she had shut him down. His cooperation would become a critical piece of the prosecution's case. The federal trial opened on a Monday morning in a packed courtroom. The gallery was full. Journalists lined the back row. Civil rights attorneys sat behind the prosecution. Families who had been targeted by Driscoll over the years filled the remaining seats, some of them seeing each other for the first time, realizing they were not alone. Prosecutors built their case methodically. First came the security footage from Maplewood Elementary, played on courtroom monitors in unbroken sequence. The jury watched Amara being led down the hallway, her small hand at her side, her face uncertain. They watched the office door close. They watched it stay closed for 20 minutes. When the audio from the interior camera was played, enhanced and transcribed for clarity, the courtroom heard a 7-year-old girl say, "My mommy didn't hurt me," over and over, while an adult voice continued pressing. Several jurors looked away. One wiped her eyes. Then came the text messages. Prosecutors displayed them on screen, one after another. "I need you to handle this one personally. You know the type. These ones always think they're above the rules." Then, the email. "Some families just don't belong in a school like this." Then, the referral history. 14 reports, 13 against families of color, 0 substantiated. Driscoll's defense argued she had acted in good faith, exercising her duty to protect children. The prosecution dismantled it in hours, showing she never consulted the school nurse, never contacted the mother, fabricated language in the CPS report, and coordinated a back-channel removal through a family member. Rita's defense collapsed entirely when her own text messages were read aloud a second time during cross-examination. Her attorney offered no rebuttal. Over 20 families testified about Driscoll's pattern. The jury deliberated for less than a day. Guilty on all counts for both defendants. Driscoll was sentenced to 4 years in federal prison. Rita received 2 years and 6 months. Officer Dale Mounier, tried separately, was fired and permanently decertified based on the investigation into his conduct history and his role in the attempted removal. Judge Nadine Coulter recused herself from the bench for the civil proceedings and retained private attorneys to file suit on behalf of her family. The lawsuit named the Lake Ridge School District, the county CPS office, Janet Driscoll, Rita Driscoll, and Officer Dale Mounier as defendants. The claim cited civil rights violations under federal law, unlawful interrogation of minors without parental consent, intentional infliction of emotional distress, fabrication of a government report, and systemic racial discrimination enabled by institutional negligence. The evidence made the case nearly impossible to defend. Security footage, text messages, email records, referral data, teacher testimony, and the sworn statement of the school nurse formed a record so thorough that settlement negotiations were brief. The case settled for $1.8 million. But the money was not the point. As part of the agreement, the district and county committed to sweeping structural reforms. Mandatory parental notification before any child could be questioned by school administrators about suspected abuse. Independent oversight of all CPS referrals originating from schools. Demographic auditing of referral patterns with public annual reporting. conflict of interest screening for all CPS caseworkers assigned to school-originated cases, mandatory implicit bias training for all school and CPS staff with quarterly assessments. The impact reached beyond the district. The state legislature, citing the Coulter case and floor debate, passed what became known as Coulter's Law, a statute requiring that all CPS emergency removal requests be reviewed and approved by an independent judicial officer before children could be separated from their parents. No more removals based on a single unverified phone call. No more back-channel coordination. No more unchecked power over families who had done nothing wrong. Nadine used a portion of the settlement to establish the Coulter Family Justice Initiative, a legal defense fund providing representation to families of color targeted by false or racially motivated CPS reports. Within its first year, the initiative took on 37 cases across 4 states. 12 resulted in formal findings of misconduct against the reporting parties. Every one of those families had been told, at some point, that the system was working as intended. 6 weeks later, on a bright Monday morning, Nadine Coulter pulled into the drop-off lane of a new school. Elijah sat in the back seat with his backpack between his knees. Amara sat beside him, her hand already reaching for the door handle. They walked in together. Elijah's shoulders were straight. Amara held her mother's hand and looked up at the building with curiosity, not fear. A teacher greeted them at the entrance with a smile. No one stopped them. No one questioned whether they belonged. No one looked at them and saw a problem to be solved. They were children walking into a school, and that was all they needed to be. Back at Maplewood Elementary, a memo circulated to all staff the following week. It was issued by the new interim principal and reviewed by the district's legal office before distribution. At the top of the page was a single still frame pulled from the school's own security footage. It showed a 7-year-old girl in a navy skirt being led down a hallway by an adult hand on her shoulder. The girl's face was turned slightly toward the camera. Her eyes were wet, her mouth was open, mid-sentence. Beneath the image were 6 words. This is what failure looks like. No names were printed. They didn't need to be. Janet Driscoll was in federal prison. Rita Driscoll was in federal prison. Dale Mounier had lost his badge, his certification, and any future in law enforcement. Gary Driscoll had resigned from the city council. The school board members who had dismissed years of complaints were facing recall campaigns. The system that had protected all of them, that had filed away grievances, buried patterns, and treated Black and Hispanic families as problems rather than people, was forced to change. Not because of outrage alone, not because of public pressure alone, but because of evidence, because of teachers who spoke up, because of a father who refused to leave, because of security cameras that captured what was meant to stay hidden, and because the woman they tried to break happened to be someone the system could not ignore. In an interview months later, Nadine Coulter was asked what she wanted people to take from what happened. She paused, then said, "I had the power to fight back. I had the credentials, the legal knowledge, and the resources. Most Black mothers in that situation don't. They lose their children to a phone call and a lie, and no one ever corrects it. That's what has to change. Not just the laws. The assumption that we don't belong, that we don't deserve the benefit of the doubt, that our families are guilty until proven innocent. That is what has to change." This case was disturbing, but the one on the right ends in a way no one expects.
Oh, you have the wrong house. My children are here. I'm a federal
Shut
judge.
up! Get on the floor!
I am Judge Monique Cole. Check your warrant.
You think that title protects you? You people think you're above the law.
In this house, I decide what the law is.
At 5:47 a.m. on a quiet Tuesday morning in the suburbs of Alexandria, Virginia, a flashbang grenade shattered the front window of a 2-story colonial home on Maple Ridge Drive. The explosion lit up the living room like a strobe, sending glass across the hardwood floor and knocking framed photos off the walls. Before the echo faded, 12 armed federal agents in full tactical gear breached the front door with a battering ram and flooded the house, rifles raised, laser sights cutting through the smoke. Inside, a black woman in a gray t-shirt and pajama pants grabbed her two children from their beds and pulled them into the upstairs hallway. She crouched over them, shielding their bodies with hers, screaming at the top of her lungs. "You have the wrong house! My children are here! You have the wrong house!" The agents didn't stop. One of them, later identified as Sergeant Kyle Briggs, reached her in seconds. He grabbed her by the back of the neck, drove her face first into the carpet, and zip-tied her wrists behind her back, while she screamed her name over and over. Her 8-year-old son James tried to reach for her and was shoved backward into the wall by another agent. Her 5-year-old daughter Amara stood frozen, barefoot on the hallway carpet, silent, eyes wide, not crying, not moving, just watching her mother pinned to the floor by men in black helmets. What none of those agents knew, what their briefing had deliberately failed to mention, was that the woman face down on that carpet was Judge Monique Cole, a sitting federal judge on the United States District Court, appointed by the President, confirmed by the Senate, one of the highest-ranking judicial officers in the state. The raid was built on a fabricated terrorism tip, and the people who built the case knew exactly who she was. They just didn't think she'd survive it. Monique Cole didn't grow up in the kind of house that got raided at dawn. She grew up in the kind of house that got forgotten. A 2-bedroom unit in the Gilmore Homes public housing project in West Baltimore, where the hallways smelled like bleach and the elevators never worked. Her mother, Lorraine, raised her alone, working double shifts as a hospital janitor and walking Monique to school every morning before the sun came up. There was no father in the picture, no safety net, no inheritance. Just a woman who told her daughter every single day that the world would try to tell her what she couldn't be, and that her only job was to prove it wrong. Monique listened. She earned a full scholarship to Howard University, graduated summa cum laude, and was accepted to Yale Law School, where she was one of only 11 black women in her class. She clerked for a Supreme Court justice, spent a decade as a federal prosecutor specializing in civil rights cases, and built a reputation for going after the cases no one else wanted to touch. Police brutality, prosecutorial misconduct, corruption inside the agencies that were supposed to protect people who looked like her. At 39, she was nominated to the federal bench. At 44, she was one of the most respected and most feared judges in the district. Officers she had sentenced despised her. Agencies she had embarrassed wanted her gone. Political figures called her rulings activist overreach. She didn't care. She lived modestly in a quiet suburb with her 2 children, James and Amara. Her husband, a Marine named David Cole, had been killed in Afghanistan 4 years earlier. She carried that loss in silence and poured everything she had into her children and her work. The legal community admired her. The people she held accountable feared her, and someone, somewhere inside the federal government, had decided she needed to be destroyed. 3 months before that flashbang grenade shattered her window, Judge Monique Cole sat behind the bench in Courtroom 4 of the federal courthouse and delivered a ruling that sent shockwaves through every law enforcement agency in the region. The case was United States versus Dreyer, a multi-agency corruption trial that had exposed something ugly at the core of the system. A regional FBI field office and 3 local police departments had been colluding for years to fabricate evidence against black community organizers, planting informants in civil rights groups, manufacturing probable cause for raids, and arresting people whose only crime was organizing voter registration drives in neighborhoods the government wanted to keep quiet. Judge Cole didn't just rule against the government, she dismantled them. She issued sanctions against the FBI's regional office, struck 11 pieces of fabricated evidence from the record, and referred 2 FBI agents and a deputy U.S. attorney for formal disciplinary review. Her written opinion was 94 pages long and described what she called a deliberate and systemic campaign to criminalize constitutionally protected activity targeting black citizens. The ruling made national headlines. Legal scholars called it one of the most significant judicial rebukes of federal law enforcement in a decade. Inside the regional FBI office, the reaction was quiet and venomous. No one challenged the ruling publicly, but behind closed doors, in break rooms and on encrypted messaging threads, conversations began. Not about reforming the office, not about accountability, about her, about how to discredit her, how to neutralize the judge who had humiliated them on the national stage. The conversations weren't official. They didn't appear on any record. They moved through back channels, old favors, and a culture of retaliation that had been baked into that office for years. A culture where challenging the Bureau meant becoming a target. And in every one of those conversations, one name kept surfacing: Supervisory Special Agent Richard Hale. Richard Hale was 51 years old and had spent 24 of those years inside the FBI. He had joined straight out of law school, climbed fast, and by his mid-30s was running the Regional Counterterrorism Task Force, a position that gave him enormous power and almost no oversight. He had a reputation for results. His unit had the highest case closure rate in the region. Federal prosecutors loved working with him because his files were always thick, his witnesses always cooperative, his evidence always just compelling enough to secure indictments. But people inside the Bureau who paid closer attention knew what that record was built on. Hale cut corners. He pressured informants into saying what he needed them to say. He constructed cases on shaky intelligence and buried contradictory evidence deep in files that defense attorneys rarely had time to fully review. He had been the subject of 2 internal reviews, both of which were closed without action after senior officials intervened on his behalf. He operated in the space between legal and defensible, and he had never once been held accountable for crossing the line. Until Judge Cole. Hale was one of the agents sanctioned in the Dreyer ruling. His name appeared 14 times in the judge's opinion. She described his unit's conduct as reckless, deceptive, and fundamentally incompatible with the constitutional obligations of federal law enforcement. For a man who had spent 2 decades believing he was untouchable, the ruling felt like a personal attack. And Hale responded the way he always did when someone challenged him. He went on offense. Quietly, methodically, without authorization. He began building a file on Monique Cole. Not through official channels, not through any sanctioned investigation. He used a confidential informant named Raymond Sykes, a man with a 15-year criminal history who had been facing drug trafficking charges and would say anything to anyone if it meant shaving time off his sentence. Hale coached Sykes over a series of meetings to fabricate a connection between Judge Cole and a domestic terrorism network. Sykes claimed that Monique had been funneling money through a fake charity to an extremist organization with ties to violent anti-government activity. None of it was true. Not a single word. But on paper, with Hale's hand guiding the narrative, it looked just real enough to move forward. Hale didn't build the case alone. He couldn't. A fabrication this size needed layers, enough paperwork and procedural scaffolding to make it look legitimate from the outside, even if the inside was hollow. So he pulled in people he trusted. Not people who believed in the case, people who owed him, people who were afraid of him, people who had learned over the years that when Richard Hale asked for something, you gave it to him and didn't ask questions. The first step was the paper trail. Hale's team took Monique Cole's legitimate financial records and began manipulating them. Charitable donations she had made to community organizations were reframed as suspicious transfers. A contribution to a Baltimore youth literacy program was flagged as a potential front. Wire transfers to her mother's bank account for medical expenses were tagged as structuring, a term used to describe deliberate evasion of federal reporting thresholds. None of it held up under honest scrutiny. But Hale wasn't building a case for trial. He was building a case for a warrant. Next came the FISA court order. Using Raymond Sykes' fabricated testimony as justification, Hale's team submitted a classified application to the Foreign Intelligence Surveillance Court requesting access to Monique's personal devices, her phone, her laptop, her home network. The application described her as a suspected financier of domestic terrorism with potential ties to foreign extremist networks. The FISA court, operating in secrecy as it always did, approved the order. Hale's team then cherry-picked metadata from her devices, pulling timestamps, GPS coordinates, and communication logs completely out of context to construct a pattern of behavior that looked damning on paper but meant nothing in reality. The affidavit was drafted by Hale's deputy and signed by a junior agent named Terrence Polk, 28 years old, 2 years on the job, too green and too intimidated to push back. Polk later admitted he hadn't read the full file. He signed because Hale told him to sign. The affidavit was then submitted to a federal magistrate in a neighboring district, Judge Arthur Brennan, a man with a long and quiet history of rubber-stamping bureau requests. Brennan signed the warrant and the arrest authorization without requesting a hearing or asking a single clarifying question. At no point in the affidavit, in the FISA application, in the briefing materials, or in any communication between Hale's team and the magistrate was it mentioned that the target of the raid was a sitting United States federal judge. That detail was deliberately omitted. When a member of Hale's team raised the issue internally, asking whether the target's judicial status needed to be disclosed, Hale shut it down immediately. "She's a civilian target with potential access to classified legal proceedings," he said. "That makes her more dangerous, not less." The framing was intentional. It made the raid seem more urgent. It justified the tactical entry. And it ensured that no one in the chain of approval would think twice about what they were authorizing. The evening before the raid, the house on Maple Ridge Drive was quiet. Monique sat at the kitchen table with James, helping him finish a history project on Thurgood Marshall. He had chosen the topic himself. She watched him carefully copy a quote onto his poster board in neat block letters, his tongue pressed against the corner of his lip in concentration, and she smiled without saying anything. Amara was already in her pajamas, curled against Monique's side on the couch while she read from a picture book about a girl who wanted to be an astronaut. Amara fell asleep before the last page. Monique carried her to bed, tucked the blanket under her chin, and stood in the doorway for a moment, watching her breathe. She went back downstairs, reviewed a set of case files for a hearing scheduled later that week, made notes in the margins, and set them in her bag by the front door. She texted her mother goodnight. Lorraine replied with a heart emoji and a reminder to eat something. Monique locked the doors, turned off the lights, and set her alarm for 6:30. She climbed into bed and closed her eyes, unaware that in less than 7 hours, men with rifles would be standing over her children. Across town, inside the FBI Regional Field Office, the tactical team assembled in a windowless briefing room at 10:15 p.m. 12 agents sat in rows of metal chairs, body armor already strapped on, helmets resting on their knees. Richard Hale stood at the front of the room beside a projected photograph of Monique Cole. He described her as a high-risk domestic terrorism suspect with potential access to weapons and sensitive government information. He said the target had connections to extremist financing networks and may attempt to destroy evidence if given warning. He recommended full tactical entry, pre-dawn breach, flashbangs authorized. Several agents exchanged glances. One of them, a junior agent named Maya Chen, 29, stared at the photograph and then leaned toward her partner. She whispered 4 words. "Isn't she a judge?" Her partner, a senior agent with 11 years on the job, didn't look at her. He kept his eyes on Hale and muttered back, "Keep quiet and follow the briefing." Chen sat back in her chair, jaw tight, hands clasped. She didn't say another word, but she didn't forget. At the bottom of the briefing sheet, in small print beneath the operational parameters and the rules of engagement, a single line noted that minor children may be present at the target location. No one read it aloud. No one discussed it. The briefing ended at 10:48 p.m. The team was told to report for deployment at 4:30 a.m. As agents filed out of the room, Hale remained at the front, arms crossed, watching them leave. He had set everything in motion. The warrant was signed. The team was ready. The target was asleep. And by morning, he believed, the judge who had humiliated him would be finished. At 5:47 a.m., the battering ram hit the front door of the house on Maple Ridge Drive with a single blow that splintered the frame and sent the deadbolt flying across the foyer. Half a second later, a flashbang grenade came through the shattered living room window and detonated against the hardwood floor. The explosion was deafening. It blew out the glass on 3 picture frames, knocked a vase off the mantel, and filled the ground floor with a burst of white light and thick, acrid smoke. Before the echo died, 12 agents in full tactical gear poured through the doorway, rifles raised, boots hammering across the floor, laser sights sweeping through the haze. Upstairs, Monique woke to the sound of the blast. For one disoriented second, she thought something had exploded in the kitchen. Then she heard the boots, the shouting, the voices barking commands she couldn't yet make out. She threw back the covers and ran. She reached James's room first. He was sitting up in bed, eyes wide, mouth open, too scared to scream. She grabbed him by the arm and pulled him into the hallway. Then Amara. Her daughter was standing in her doorway, barefoot, clutching a stuffed rabbit, completely still. Monique scooped her up with one arm and pulled both children to the floor, pressing them beneath her, shielding them with her body. She screamed down the stairwell. "My name is Monique Cole. I am a federal judge. You have the wrong house. My children are here. Do not come up here with weapons around my children." They came anyway. Sergeant Kyle Briggs was the first agent up the stairs. He was 36 years old, built heavy, with a reputation on the tactical team for moving fast and asking questions later. He saw a woman crouched over 2 children in a dark hallway, and he didn't pause. He grabbed Monique by the hair, wrenched her backward, and drove her face first into the carpet. She screamed again. "I'm a federal judge! I'm a federal judge!" Briggs planted a knee in her lower back, pulled her arms behind her, and zip-tied her wrists so tight the plastic cut into her skin immediately. "Shut your mouth," he said. "Stop resisting." She wasn't resisting. James lunged toward his mother, crying, reaching for her. A second agent caught him by the shoulder and shoved him backward into the wall, hard enough to knock the air out of him. The boy slid to the floor, gasping, his eyes locked on his mother's face pressed sideways into the carpet. Amara was pulled from where she had been clinging to Monique's leg. She screamed as an agent carried her down the hallway and into the master bedroom, closing the door behind them. Monique could hear her daughter wailing through the wall. She couldn't move. She couldn't reach either of her children. She lay face down on the carpet for 11 minutes. While she was pinned to the floor, agents moved through the house with methodical aggression. They pulled books off shelves and threw them on the floor. They overturned furniture. They emptied kitchen drawers. They seized her laptop from the kitchen table, her personal journals from the nightstand, and her legal files from the bag by the front door. Those files contained sealed federal case documents, judicial correspondence, and privileged attorney communications, materials protected by judicial immunity and constitutional separation of powers. None of the agents hesitated. None of them asked what the documents were. They bagged everything. It was during the search of the kitchen that an agent named Torres opened a leather folio and found what was inside. A federal judicial identification card. A photo of Monique Cole. The words United States District Court Judge beneath her name. He stared at it for 3 full seconds. Then he looked up, turned toward the hallway, and called the team leader over. His voice was barely above a whisper, but everyone in the room heard it. "She's a judge. She's a federal judge." The room went quiet. The team leader, Agent Vargas, stood in the doorway between the living room and the hallway, holding the judicial ID in one hand and his radio in the other. Monique was still face down on the carpet, zip-tied, bleeding slightly from a rug burn that ran from her cheekbone to her jaw. James sat against the wall with his knees pulled to his chest, shaking. Amara's screams from behind the bedroom door had turned into a low, steady sob that hadn't stopped. Vargas keyed his radio. "Command, this is Vargas on scene at the target location. We have a situation. The target is identifying as a federal judge. We found judicial credentials, requesting guidance." There was a pause. Then Hale's voice came through, flat, controlled, and unmistakably deliberate. "Continue the search. Secure all materials. Transport the subject for processing." Vargas didn't move. He looked at the ID again. He looked at Monique on the floor. He looked at the child against the wall. His hand stayed on the radio. From behind him, a voice broke the silence. Maya Chen stepped forward from the group of agents near the stairwell. She was still in full tactical gear, helmet on, rifle lowered. Her voice was steady but firm. "I'm not participating in this any further. That woman is a sitting federal judge on the United States District Court. If we transport her for processing, every single person in this house will be facing federal charges. Not administrative review, federal charges. Obstruction of justice, assault on a judicial officer, deprivation of rights under color of law. This is over." Briggs turned toward her. "We have orders. Stand down and do your job." Chen didn't flinch. "Our orders are unlawful, and if you touch her again, I will personally file the complaint myself." The room split. Briggs looked to Vargas for backup. Another agent stepped closer to Chen, not threatening, but watching. Vargas raised a hand. "Quiet. Everybody quiet." He pulled out his personal phone and dialed a number that bypassed Hale entirely. He called the FBI's Office of Professional Responsibility directly. The call lasted less than 4 minutes. When Vargas lowered the phone, his face had changed. He looked at the team and spoke in a voice that left no room for argument. "Stand down. Weapons safe. Nobody touches anything else. We're done." Briggs exhaled through his nose. "This is going to blow back on all of us." Chen looked at him. "It already has." An agent opened the bedroom door and brought Amara back into the hallway. The girl's face was swollen from crying, her pajamas damp. She ran to her mother, who was still on the floor, still zip-tied. Monique couldn't hold her. She could only press her face against her daughter's hair and whisper that it was okay, that it was over, that Mommy was right here. But her hands were still bound behind her back. The order to release her hadn't come yet. When it finally did, 3 minutes later, an agent knelt beside her and cut the zip ties with a pair of trauma shears. The plastic had left deep red welts on both wrists. Monique sat up slowly, pulled both children into her arms, and held them on the floor of her own hallway surrounded by broken glass, overturned furniture, and the scattered remains of the life she had built. She didn't cry. She didn't shout. She looked at Vargas, and in a voice so controlled it made every agent in the room look away, she said 5 words. "Get out of my house." Monique didn't move from the hallway floor for a long time. She sat with her back against the wall, James under one arm, Amara under the other, and she held them in the wreckage of their home. The living room was destroyed. The couch had been flipped. Bookshelves were emptied across the floor. Broken glass from the front window glittered across the hardwood, catching the early morning light that was now streaming through the hole where the flashbang had come through. The smell of chemical residue hung in the air, sharp and metallic, mixing with the cold draft from outside. James was shaking. Not crying anymore, just shaking. His eyes were open but unfocused, staring at a point on the far wall. He hadn't spoken a word since the agent shoved him. When Monique whispered his name, he didn't respond. She pressed her lips to the top of his head and held him tighter. Amara had wet herself at some point during the ordeal. Her pajama pants were soaked, and she clung to Monique's shirt with both fists, her face buried against her mother's chest, making small hiccuping sounds that came in waves. She hadn't let go since the zip ties were cut. Outside, the remaining agents stood on the front lawn in a loose cluster. Some had removed their helmets. A few spoke quietly into phones. None of them looked at the house. Neighbors had begun gathering on the sidewalk across the street, some in bathrobes, some holding coffee, all of them staring at the tactical vehicles parked along the curb and the shattered front window of a home they had walked past 1,000 times. A woman 3 doors down was already recording on her phone. A man in a veteran's cap stood at the edge of his driveway with his arms crossed, watching the agents with an expression that sat somewhere between anger and disbelief. At 6:31 a.m., a silver sedan screeched to a stop at the end of the driveway. Lorraine Cole, 68 years old, barely 5 feet tall, got out of the car before the engine was fully off. She saw the broken window, the agents, the tactical gear, and she started running. She pushed past the first agent she reached, shoving his arm aside when he tried to stop her. "Where is my daughter? Where are my grandchildren?" "What did you do?" A second agent stepped into her path and she screamed in his face. "That is a federal judge's house! Do you understand what you've done? Get away from me! Get away from this house!" She found Monique and the children on the hallway floor and dropped to her knees beside them. She pulled Amara into her arms and pressed James's head against her shoulder and said nothing for a long time. She just held them. By 7:15, local police arrived, called by neighbors. They were confused. No one had notified them of a federal operation in their jurisdiction. They stood on the lawn exchanging tense words with the remaining FBI agents who refused to answer questions and said only that the matter was classified. By 8 o'clock, the first news van appeared. By 8:30, there were 4. Cameras were rolling from the street. A helicopter circled overhead. The FBI issued no statement. Hale was unreachable. His phone went straight to voicemail. The agents who had conducted the raid were ordered back to the field office by a terse call from the regional director's assistant. They were told to speak to no one, write nothing, and wait for further instructions. Inside the house, Monique sat at her kitchen table, the same table where James had worked on his Thurgood Marshall project the night before. The poster board was still there, now crumpled on the floor where an agent had knocked it off. She picked up her phone and made 2 calls. The first was to Chief Judge Harold Whitmore of the Eastern District of Virginia. She told him what had happened. He was silent for 10 seconds before he said he would handle it personally. The second call was to the Office of the Attorney General of the United States. She was transferred 3 times. When she finally reached a senior aide, she spoke 1 sentence, her voice low and perfectly controlled. "They raided my home, terrorized my children, and put me on the floor in zip ties. I want every name, every document, and every recording, and I want them by end of day." She hung up and set the phone on the table. Then she looked at her mother, who was rocking Amara in her arms, and said quietly, "They picked the wrong house." By noon, the Department of Justice Office of the Inspector General had opened an emergency investigation, the fastest activation of its kind in over a decade. The sealed FISA application that had authorized surveillance of Judge Monique Cole's personal devices was pulled from the classified archive and placed under immediate review by a team of senior attorneys with top-secret clearance. What they found took less than 2 hours to dismantle. The informant's claims were unsubstantiated. Raymond Sykes, the confidential source whose testimony had formed the backbone of the application, had no verifiable connection to any terrorism network. His statements were internally contradictory, unsupported by independent evidence, and in several places appeared to have been scripted. The financial evidence was manipulated. Charitable donations to legitimate organizations had been reframed as suspicious transfers. Routine wire transfers to Monique's mother had been flagged as structuring, despite falling well below federal reporting thresholds. Metadata from her personal devices had been stripped of context and arranged to suggest patterns that didn't exist. And the omission of Monique's judicial status from every document in the file, the warrant application, the FISA request, the tactical briefing, the affidavit, was deemed deliberate. Not an oversight, not a clerical error, a conscious decision to hide the identity of the target from every reviewing authority in the chain. The Inspector General's preliminary report used language rarely seen in federal documents. It described the case file as fabricated from its foundation and called the raid a gross abuse of federal investigative authority. A copy was sent to the Attorney General by secure courier before the end of the day. By mid-afternoon, congressional leaders had been briefed. The chairman of the Senate Judiciary Committee released a statement calling the raid an assault on the independence of the federal judiciary, and demanded a full public accounting within 72 hours. The ranking member of the House Intelligence Committee requested an emergency classified briefing on how a FISA court order had been obtained using fabricated evidence. By evening, the Chief Justice of the United States had been personally informed. No public statement was issued from the Supreme Court, but sources inside the judiciary later confirmed that the Chief Justice made a single phone call to the Attorney General, lasting less than 3 minutes. The contents of that call were never disclosed. They didn't need to be. The media coverage detonated. Every major network led with the story. Cable news ran split screens showing the quiet suburban house with its shattered window beside Monique's official judicial portrait. Chyrons read, "Federal judge zip-tied in pre-dawn raid," and "FBI accused of fabricating terrorism case against black judge." Legal analysts described the case as unprecedented. Former federal prosecutors called it the most dangerous abuse of investigative power they had ever seen. But it was the doorbell camera footage from a neighbor's house across the street that broke the story wide open. The video, 47 seconds long, showed agents in full tactical gear leading two small children out the front door of the house in the gray pre-dawn light. James was barefoot, wearing pajama pants, being guided by the arm by an agent twice his size. Amara was being carried by another agent, her face twisted in a scream, her small hands reaching back toward the house. The footage was posted online by the neighbor's adult son. Within 6 hours, it had been viewed over 12 million times. Within 12 hours, it had been shared by senators, civil rights leaders, journalists, attorneys, and millions of ordinary people who watched a 5-year-old girl screaming for her mother and understood exactly what had happened. The public outrage was immediate and overwhelming. Protest vigils formed outside the FBI's regional field office. Legal organizations issued joint statements condemning the raid. The National Bar Association called for an independent federal commission. Hashtags trended for days. And somewhere inside a quiet office at the Department of Justice, investigators began pulling the thread that would lead them directly to the man who had built the case from nothing and set the entire disaster in motion. Richard Hale was placed on immediate suspension at 4:17 p.m. on the day of the raid. 2 federal marshals met him in the parking garage of the FBI regional field office as he returned from wherever he had been hiding since morning. They handed him a letter signed by the Deputy Attorney General, informing him that he was relieved of all duties, stripped of his credentials, and barred from entering any federal facility pending the outcome of the investigation. His service weapon was confiscated on the spot. His badge was taken. His face showed nothing as he read the letter, but his hands were trembling. Within the hour, a team from the Inspector General's office entered his office on the 4th floor with a federal seizure warrant. They sealed the room with tamper-evident tape, disconnected his desktop computer, removed 3 external hard drives, and boxed every file in every drawer. His government-issued phone was taken. His personal phone was subpoenaed by the end of the day. His email accounts, both official and personal, were placed under a federal preservation order. Every message he had sent or received in the past 6 months was now in the hands of investigators. What they found was damning. Not circumstantial, not ambiguous, damning. Internal messages recovered from Hale's encrypted bureau account showed a clear and deliberate timeline. 3 days after Judge Cole's ruling in the Dreyer case, Hale sent a message to his deputy that read, "She wants to come after us. Fine. Let's see how she handles being on the other side of an investigation." 2 weeks later, he forwarded a file on Raymond Sykes to a colleague with the note, "This one will say whatever we need. He's facing 15 years. He'll cooperate." A month before the raid, Hale wrote in a group thread with 3 members of his team, "Keep her judicial status out of every filing. If it shows up anywhere, this gets flagged before we move. I don't want oversight on this. I want results." The messages continued in a trail that investigators would later describe as the most explicit record of retaliatory fabrication they had ever encountered inside a federal agency. Hale had directed every step: the coach testimony, the manipulated financials, the FISA application, the omission of Monique's identity, the tactical briefing that described her as a civilian. Every lie had his fingerprints on it. Raymond Sykes, the confidential informant, was brought in for questioning within 48 hours of the raid. He lasted less than an hour before he broke. Sitting in a federal interview room with 2 DOJ attorneys and an inspector general investigator across the table, Sykes recanted everything. He admitted Hale had coached him in 3 separate meetings, telling him exactly what to say about Judge Cole, what financial connections to describe, which organizations to name. Hale had promised him a reduced sentence and relocation through witness protection if the case moved forward successfully. Sykes said he never met Monique Cole. He had never heard her name before Hale mentioned it. He had no knowledge of any terrorism network. He made it all up because Hale told him to and because he was desperate. The junior agent who signed the affidavit, Terrence Polk, cooperated with investigators the same day. He confirmed he had been pressured by Hale to sign the document without reviewing the full case file. He said Hale told him the target was a civilian with possible ties to domestic extremism and that the case was time-sensitive. Polk said he never saw any reference to a judicial title. He never knew the target was a federal judge. When investigators showed him the messages proving Hale had ordered the omission, Polk put his head in his hands and said, "He told me it was clean. He told me everything had been vetted." Federal Magistrate Arthur Brennan, the judge who signed the search warrant and arrest authorization, was referred for formal judicial review within the week. Investigators found no direct communication between Brennan and Hale, but the pattern was unmistakable. Brennan had approved the warrant without a hearing, without requesting supplemental documentation, and without verifying the identity of the target, despite the filing containing enough red flags to warrant basic due diligence. Records showed Brennan had approved 97% of all warrant requests submitted by Hale's unit over the past 4 years, a rate that senior judicial officials described as deeply troubling. Whether Brennan had acted out of negligence or deliberate complicity would be the subject of a separate investigation. But either way, his time on the bench was over. Hale sat in his living room that night with the curtains drawn and the television off. His phone was gone. His badge was gone. His office was sealed. The people he had trusted to stay quiet were lining up to cooperate, and the case he had built to destroy a judge was now destroying him, piece by piece, in a way he could not stop and could not control. 4 days after the raid, the Attorney General of the United States stood behind a podium in the main briefing room of the Department of Justice and addressed the nation. The room was packed. Every major news outlet had a camera in position. The Attorney General spoke for 11 minutes without taking a question. What happened to Judge Monique Cole and her family was an unconscionable abuse of federal power and a direct attack on the independence of the American judiciary. A sitting federal judge was targeted, surveilled, and subjected to a violent pre-dawn raid based on evidence that was fabricated from the ground up by individuals within the FBI who used their authority not to protect this country, but to punish a judge for doing her job. Her children were ripped from their beds. Her home was destroyed. Her constitutional rights were violated in ways that strike at the very foundation of our system of government. This department will pursue full accountability for every individual involved, without exception and without compromise. The statement was broadcast live on every network. Within the hour, the president released a written statement calling the raid a stain on the integrity of federal law enforcement and affirming the administration's full support for the independent investigation. The charges came the next morning. A federal grand jury returned a sealed indictment against Supervisory Special Agent Richard Hale on 5 counts. Conspiracy to deprive civil rights under 18 U.S.C. Section 241. Fabrication of evidence in a federal investigation. Obstruction of justice. Abuse of authority. And retaliatory conduct against a federal official, a charge that carried enhanced penalties because the target was a sitting judge. Hale was arrested at his home at 6 a.m. by U.S. Marshals. He was handcuffed in his driveway in front of his neighbors. The irony of the hour was not lost on anyone. Sergeant Kyle Briggs, the tactical agent who had grabbed Monique by the hair, forced her to the ground, and zip-tied her while her children screamed, was charged separately with assault under color of law and excessive use of force against a federal official. His body camera footage, which had captured every second of his conduct during the raid, was entered into the federal record as primary evidence. 3 additional agents who participated in the raid were placed under formal investigation for failure to intervene, destruction of privileged materials, and conduct unbecoming of a federal officer. Federal Magistrate Arthur Brennan was suspended from the bench pending the outcome of a judicial conduct review. His caseload was reassigned, His chambers were sealed. A preliminary review found that he had approved the warrant in under 9 minutes, without reading the full affidavit, a fact that would feature prominently in the misconduct proceedings that followed. The FBI director requested a private meeting with Judge Cole at her home. He wanted to deliver a personal apology on behalf of the Bureau. Monique's attorney, a former federal prosecutor named David Harmon, responded on her behalf within the hour. The message was 3 sentences long. Judge Cole will not be meeting with the director. An apology does not repair what was done to her children. When the government is ready to discuss accountability, not regret, her legal team will be available. The statement was leaked to the press within minutes. It led every evening broadcast. The headline on the front page of the Washington Post the next morning read, "Apologies don't fix what my children saw." Beneath it was a photograph of the shattered front window of the house on Maple Ridge Drive, the flashbang scorch marks still visible on the hardwood floor inside. The trial of Richard Hale began on a Monday morning in the same federal courthouse where Judge Monique Cole had spent years presiding over cases from the bench. The courtroom was packed. Every seat in the gallery was taken. Journalists filled the press section. Legal observers from civil rights organizations, bar associations, and judicial advocacy groups lined the back wall. Outside, a crowd had gathered on the courthouse steps, holding signs and watching the proceedings on phones through a live audio feed that had been authorized by the presiding judge. The prosecution's case was methodical and devastating. Over the course of 9 days, federal attorneys dismantled every piece of the fabricated case that Hale had built against Monique Cole. Not by arguing interpretation, but by showing the jury exactly how each lie had been constructed, who had constructed it, and why. Raymond Sykes took the stand on the second day. He described in detail how Hale had recruited him, coached him, and fed him the specific language to use in his testimony. He told the jury Hale had met with him 3 times before the FISA application was submitted, each time refining the story, adjusting the details, and making the fabricated connection between Monique and the extremist network sound more credible. He said Hale had promised him a reduced sentence and relocation. He said he had never heard Monique Cole's name before Hale mentioned it. He said he made it all up because he was facing 15 years, and Hale offered him a way out. Terrence Polk, the junior agent who signed the affidavit, testified on the 4th day. His voice cracked several times during his testimony. He described how Hale had pressured him into signing a document he hadn't fully read, how Hale told him the case was time-sensitive and the target was a civilian, how Hale assured him everything had been vetted by senior attorneys when it hadn't. When the prosecutor asked Polk if he knew at the time of signing that the target was a sitting federal judge, Polk shook his head and said quietly, "No, he never told me. I would not have signed it if I had known. I should have read the file. I didn't. That's on me." The most damaging evidence came on the 6th day, when prosecutors read Hale's internal messages aloud to the jury. The courtroom was silent as each message appeared on a screen beside the witness stand. "She wants to come after us. Fine. Let's see how she handles being on the other side of an investigation. That woman thinks the bench makes her untouchable. Keep her judicial status out of every filing." In the message that prosecutors returned to 3 times during closing arguments, the one that captured the full scope of Hale's intent. She needs to be reminded who holds real power in this country. It's not the judges. It's the people who decide who gets investigated. The defense tried. Hale's attorney, a veteran federal defense lawyer from Washington, argued that Hale had acted on intelligence he believed to be genuine, that the informant had misled him, and that the failure to disclose Monique's judicial status was an administrative oversight rather than a deliberate act. He characterized Hale as a dedicated agent who had served his country for over 2 decades and made a judgment error under pressure. The jury didn't buy any of it. The messages were too clear. The testimony was too consistent. The fabrication was too deliberate. Every piece of the defense's narrative collapsed under the weight of evidence that Hale himself had created. A paper trail of arrogance written by a man who never imagined anyone would read it. Deliberation took less than 5 hours. The jury returned with guilty verdicts on all 5 counts: conspiracy to deprive civil rights, fabrication of evidence, obstruction of justice, abuse of authority, retaliatory conduct against a federal official. At sentencing, the judge spoke for nearly 20 minutes. He described Hale's conduct as a calculated assault on the rule of law, carried out by a man who swore an oath to uphold it. He noted that Hale had used the full machinery of federal law enforcement to target a judge who had done nothing more than hold the government accountable. He spoke about the children, about the flashbang that detonated in their home, about the 5-year-old girl carried screaming from her mother's arms, about the 8-year-old boy who still had not returned to sleeping in his own bed. Richard Hale was sentenced to 12 years in federal prison. It was one of the longest sentences ever handed to a federal agent for abuse of authority. He stood motionless as the sentence was read. He did not speak. He did not apologize. He was led from the courtroom in handcuffs through a side door, while cameras flashed from the gallery and the crowd outside erupted in applause that could be heard through the courthouse walls. Kyle Briggs was tried separately 2 months later. The case was shorter. The body camera footage did most of the work. The jury watched Briggs grab a woman by the hair, force her face into the carpet, and zip-tie her wrists while she screamed that she was a federal judge, and her children cried in the background. They watched him plant a knee in her back and tell her to shut her mouth. They watched James reach for his mother and get shoved into the wall. Use of force experts testified there was no tactical justification for any of the force Briggs used against a compliant, unarmed woman in her own home. Briggs' attorney argued he was following orders from a superior and acting on the briefing he had been given. The jury deliberated for 3 hours. Guilty on all counts. Briggs was sentenced to 4 years in federal prison. As he was led away, he looked back at the gallery once. No one met his eyes. The civil rights lawsuit was filed 6 weeks after the criminal verdicts. Monique Cole's legal team, led by attorney David Harmon and supported by a coalition of civil rights organizations, named the FBI, the Department of Justice, Supervisory Special Agent Richard Hale, Sergeant Kyle Briggs, and 6 additional agents as defendants. The complaint ran 142 pages and cited unlawful search and seizure, excessive force, fabrication of evidence, deprivation of constitutional rights under color of law, intentional infliction of emotional distress, and violation of judicial immunity. The evidence was so overwhelming that settlement negotiations began before the first deposition was scheduled. The government's attorneys knew what the body camera footage showed. They knew what the internal messages said. They knew what the informant had admitted. And they knew that a federal jury had already convicted the primary architect of the raid on every count. There was no version of this case that ended well for the defense. There was only the question of how much it would cost. The case settled for $14.7 million, one of the largest settlements ever paid by the federal government for a wrongful raid. The amount was significant, but it was the non-monetary terms that would carry the most lasting impact. The settlement mandated sweeping structural reforms across federal law enforcement. Independent judicial review would now be required for all warrant applications targeting attorneys, judges, or officers of the court. No warrant could be issued against a member of the judiciary without the target's status being disclosed in the application and reviewed by a specially appointed oversight judge. Mandatory identity disclosure requirements were implemented for all federal search warrants, ensuring that the deliberate omission that had enabled the raid on Monique's home could never be replicated through the same procedural gap. A civilian oversight panel for counterterrorism operations was created, with authority to review case files, interview agents, and refer misconduct for investigation, the first body of its kind with genuine enforcement power over national security operations. And new whistleblower protections were codified specifically for federal agents who challenged unlawful orders during operations in the field. Those protections were written with one person in mind. Maya Chen, the junior agent who had stood in Monique Cole's hallway and refused to participate in the raid, was promoted within 6 months of the settlement. She was later invited to testify before the Senate Judiciary Committee about the culture of retaliation inside the FBI, about what it felt like to be the only person in a room full of armed agents willing to say out loud what everyone else already knew was wrong. Her testimony lasted 2 hours. She described the briefing, the moment she recognized Monique's name, the silence when she whispered to her partner, the way he told her to keep quiet. She described standing in that hallway, watching a woman on the floor with zip-tied wrists and 2 terrified children, and making a decision that she knew could end her career. She said she would make the same decision again without hesitation. Monique used a portion of the settlement to establish the Cole Justice Initiative, a foundation dedicated to providing legal defense and psychological support to families subjected to wrongful raids, prosecutorial abuse, and retaliatory investigations. The foundation partnered with civil rights attorneys, trauma counselors, and community organizations across the country to build a network of resources for people who had been targeted by the system and had no one to call. Within its first year, the initiative had taken on 31 cases in 14 states. Monique oversaw its operations personally, reviewing every intake file, because she understood something most people never had to learn: that when the government comes for you in the dark, the law only protects you if someone is willing to fight for it in the light. 6 months after the raid, on a clear Monday morning in early fall, Judge Monique Cole walked through the side entrance of the federal courthouse, took the elevator to the 3rd floor, and stepped into courtroom 4. She wore the same black robe she had worn for 5 years on the bench. Her steps were steady. Her posture was straight. Nothing about her appearance suggested that 6 months earlier, she had been face down on her own hallway carpet, with zip ties cutting into her wrists, and her children screaming in the next room. The courtroom was packed. Every seat in the gallery was taken. Attorneys filled the front rows. Journalists sat with notebooks open. Civil rights advocates and legal observers lined the back wall. And in the very first row, Lorraine Cole sat with her hands folded in her lap. James was beside her, quiet, his left hand gripping the edge of the bench, a habit his therapist said would fade with time. Amara sat on Lorraine's other side, legs swinging above the floor, clutching the same stuffed rabbit she had been holding the morning the agents came. She still woke up screaming some nights, but she was there. They both were. Monique looked out at the gallery. She saw the attorneys, the press, her mother's face, her son's tight grip, her daughter's small hands. She didn't make a speech. She didn't reference the raid or the trial or the settlement. She sat down, adjusted the microphone, and said 5 words. "This court is in session." Outside, a training bulletin circulated through federal law enforcement agencies nationwide. It showed a doorbell camera still frame, 2 agents in tactical gear walking a barefoot boy down a suburban driveway while carrying a screaming 5-year-old girl reaching back toward the house. Beneath the image, 6 words in plain black letters. This is what abuse of power looks like. No names were printed. They didn't need to be. The careers were already gone. If you think this situation was bad, wait until you see what happens in the case on the right-hand side.